Okay, so we begin with the test preparation and we left here. I've changed the location of the folder so I can record even longer this time. Well, uploading is going to be the trouble giver anyway. Okay, meaning, nature, scope, and sources of environmental law. That's where we left, and this is where we're going to start. So, meaning of environmental law. So in the the first part we discussed about the meaning of environment. Now this is environmental law, so it's a little different. So environmental law is body of law. Okay, so it is a body of law which is a system of complex and interlocking statutes, common laws, treaties, conventions, regulations, and policies that seek to protect the natural environment, which may be affected, impacted, or endangered by human activities, and that is known as environmental law. I don't know where this definition is taken from, but it is pretty elaborate. So, environmental law is a body of law, very first thing, and it is a system of complex and interlocking statutes. Okay, so environmental law is a system of complex and interlocking statutes, common laws, treaties, conventions, regulations, and policies that seek to protect the natural environment. System of complex and interlocking statutes, common laws, treaties and conventions, regulations and policies that seek to protect the natural environment, which may be affected, impacted, or endangered by human activities. This is known as this is not the right grammar and it's not necessary anyway. So okay, which may be affected, impacted, or endangered by human activity. So environmental law is a body of law which is a system of complex and interlocking statutes, common laws, treaties, conventions, regulations, and policies that seek to protect the natural environment. Treaties, conventions, regulations, and policies. Okay. Or environmental law is body of central and state statutes intended to protect the environment, wildlife, land beauty, prevent pollution, overcutting of forests, save endangered species, conserve water, develop and follow general plans, and prevent damaging practices. Good Lord! And how am I supposed to memorize this? Okay, so environmental law is a body of central and state statutes. Okay, so it is a body of central and state statutes, and it is intended central and state statutes which are intended to protect the environment. And talk about the inclusions. Environment, to protect the environment, wildlife, okay, land beauty, prevent pollutions and deforestation, save endangered species, conserve water, develop and follow general plans, and prevent damaging practices. Okay, so that's about environmental law. Move on. Now, Rogers defines environmental law as the law of planetary housekeeping. This is a good definition. Rogers' definition: the law of planetary housekeeping, protecting the planet and its people from activities that upset the earth and its life sustaining capacity. So it is the law of planetary housekeeping which protects the planet and its people which protects the planet and its people from activities that upset, that harm the environment, from activities that harm the earth and its life sustaining capacities. That is what Rogers says. Law of planetary housekeeping, protecting the planet and its people from activities that harm the earth and its life sustaining capacities. Next, scope of environmental law. Environmental law is a branch of law primarily concerned with pollution control. Okay, now these are the aspects with which environmental law deals with. So environmental law is a branch of law which deals with pollution control, and that can be air, climate change, water, noise, land contamination, and environmentally hazardous chemicals, and also pollution control. Then we have national parks, wildlife, flora and fauna, biodiversity, environmental planning, heritage conservation, sustainable development, conditions of land, air, and water. So these are the aspects with which environmental law deals with. So it is the scope of environmental law. So the scope of environmental law extends to pollution control, national parks, wildlife, flora and fauna, biodiversity, environmental planning, heritage conservation, sustainable development, and conditions of land, air, and water. How do we memorize this? So pollution control, national parks, wildlife, okay, wildlife and all, and then okay, things that are found in wildlife, flora and fauna, and biodiversity, of course, the whole thing. Environmental planning, then we have heritage conservation, environmental planning, of course, heritage conservation, and sustainable development is like, of course, it's one of the most important thing, sustainable development, and conditions of land, air, and water. So there are 9 points. Okay, just take the time, memorize this thing. Yeah, I think I'm done pretty much. Like pollution control, national parks, wildlife, and things found there like flora and fauna, and then we have biodiversity, and then there is planning, environmental planning, and then there is um, uh, environmental planning, and then heritage conservation, heritage conservation and sustainable development, and then finally we have conditions of land, air, and water. Anyway, so that's done. In modern times, environmental law protection is largely confined to control of pollution. So, control of pollution by hazardous products, gases, and effluents which are byproducts of industrialization. So, in modern times, it is largely confined to the scope of environmental law is largely confined to the control of pollution by hazardous products like gases and effluents. However, preventive and remedial measures to meet the hazards of pollution are also major concerns of environmental law. So, preventive and remedial measures to meet the hazards of pollution are also major concerns. So, control of pollution is one thing, like you limit the amount of pollution that is occurring, and also to meet the hazards of pollution. Measures to meet the hazards is also another concern of environmental law. So that's also another scope of environmental law. Right. Now, sources of environmental law. According to M. Longlin, a guy, I don't know. Oh, who wants to see M. Longlin? Me. Let's see. M. Longlin. How do you look like? Good lord. Okay. I didn't expect to see bones. M. Longlin. M. Longlin. Why do I see things like these? I mean, he's a guy. Maybe he's not famous or something. I don't know. Okay, let's move on. According to M. Longland, environmental law has been derived from two sources, namely common law developed by the courts through judicial precedents, and second is from statutory law with regulations or bylaws made thereunder. So there are two different sources from which environmental law is taken. So these two sources are, one, we have common law, and we also have statutory law. Okay, so common law develops based on judicial precedents and all. That's how common law comes about. Common law derived from the judicial precedents, and statutory law that comes from bylaws and all made by the parliament with regulations or bylaws made thereunder. Okay, cool. So in India, the principal source of environmental law are, number one, we have the Constitution of India, which protects a large, which gives the basis for the protection of environment. Constitution of India is one. Second, we have statutes that are enacted by the Parliament. Okay. Third is judicial activism because of courts intervention and all. And fourth is because of international agreement. So we have the Constitution, we have statutes enacted by the Parliament, we have judicial activism going on, and fourth, we have international agreements. So these are the four sources in India. Other than that, according to M. Longland, we have two places. One is common law because of development through judicial precedents, and second one is because of statutory law that has been enacted by Parliament. Okay. Environmental law has national as well as international perspectives. So environmental law has national as well as international perspectives. International treaties, conventions, protocols, agreements, etc. have led to origin, growth, and regulation of environmental law in India. So there are both national as well as international perspectives, and because of international treaties, conventions, protocols, agreements, etc., it has given a lot of growth and development in the environmental law of our own country. So now the United Nations Conference on Human Environment and Development at Stockholm in 1972 resulted in adoption of Stockholm Declaration. So our country adopted the Stockholm Declaration based on the because of the United Nations Conference on Human Environment and Development. So United Nations Conference on Human Environment and Development at Stockholm resulted in the adoption of the Stockholm Declaration on Stockholm Declaration on Environment Protection and Sustainable Development. So this conference was responsible for the adoption of the Stockholm Declaration on Environment Protection and Sustainable Development. So United Nations Conference on Human Environment and Development at Stockholm in 1972 resulted in the adoption of Stockholm Declaration on Environment Protection and Sustainable Development. Okay, moving on. With an object to prevent depletion of ozone layer, Vienna Convention and Montreal Protocol concluded specific provisions to deal with the depletion of ozone layer. So depletion of ozone layer is because of our adoption. With an object to prevent the depletion of ozone layer, we adopted the Vienna Convention and the Montreal Protocol. Right. Vienna Convention and Montreal Protocol for the prevention of depletion of ozone layer. Vienna Convention and Montreal Protocol. Rio Declaration concentrated the concept of environment protection and sustainable development. Rio Declaration concentrated the concept of environment protection and sustainable development. Environment protection and sustainable development together, that is Rio Declaration. Okay, moving on. India, being a signatory of international conventions and various protocols, has enacted and amended the various environmental laws to suit the changing conditions of environment in India. Some of these acts are Noise Pollution Regulation and Control Rules 2000, the Cigarettes and Other Tobacco Products Prohibition of Advertisement and Regulation of Trade and Commerce, Production, Supply and Distribution Act 2003. Okay. Cigarettes and Other Tobacco Products Act 2003, Noise Pollution Act. And then there is Ozone Depleting Substances Rules 2000, Ozone Depleting Substances Rule, Radiation Protection Rule 1971. So these are certain Radiation Protection Rules 1971. So these are certain enactments on which India, being a signatory to international convention and various protocols, have enacted or amended certain rules. Okay, so amended certain rules to suit the changing conditions of the environment. So we have noise pollution rules 2000, Cigarette and Other Tobacco Products Act 2003. We have ozone depleting substances rules. We have radiation protection rules 1971. Done. Next, whether environmental law is a private law or a public law. So before we begin with things, we need to know whether environmental law, like what exactly is private law and public law. So first, what itself is law? I mean, okay, we can go through it. Law is an instrument which regulates human behavior. In its simplest form, law is an instrument which regulates human behavior. So in other words, through the instrumentality of law, the state regulates the conduct of human beings. So through the instrumentality of the law, the state regulates the conduct of human beings and thereby maintains law and order and ensures social security. Through the instrumentality of the law, state regulates the conduct of human beings and thereby maintain law and order in the society. Okay, the law may be therefore divided into private law and public law. Okay, so what is private law? Private law protects the rights of an individual or group of individuals. Before we even think about this thing, this part, before we even think about this part, pay close attention to this. Private law governs the relationship between individuals. Okay, this is the difference. Now, when we let's learn on the basis of distinction between private law and public law, things will become much more clear. Now, private law governs the relationship between individuals, and public law governs the relationship between the state and the individual. Okay. So public law deals with relationship between state and individual, while private law governs the relationship between the individuals themselves. So private law protects the rights of an individual or group of individual or particular individuals. So if a person gets affected, then that injured person can go and file a suit or whatever. Or when it comes to public law, a person can approach the court even if he is not an injured person, or even if he is not the one who has the locus standi. So locus standi plays an important part in both private law and public law. Public law public law protects the rights of people in general, or rights of people in general, or public in general, or society as a whole. Now the difference itself you'll see when you look at the examples. Now look at Indian Contract Act, Transfer of Property Act 1872. So 1882. So these are certain acts under which you regulate the rights, and you impose rights and duties on the individual and the interaction between the individuals, and not the interactions and individuals is the main important thing here. And when it comes to public law, the interaction is between the individual and the state. So that is the main difference between private law and public law. Examples are important: Indian Contract Act 1872, private law; Transfer of Property Act 1882, it's also private law. Hindu Marriage Act, Christian Marriage Act, and all of these things which regulate the behavior and the actions of individuals and their relationship between each other is what is private law all about. Torts also comes under private law. When you talk about public law, we have constitutional law. So this is a vast topic. Okay, constitutional law, administrative law, criminal laws. So these are what is known as the public laws. Okay. So further, in the case of private laws, the affected or aggrieved or injured person or persons alone can move or approach the court for relief. Locus standi is important when it comes to private law. Okay. Whereas in case of public law, any member of the public can move or approach court. Any member. In addition, any public spirited citizen can move the court by filing a public interest litigation. So the medium would be public interest litigation under Article 32 or concerned High Court under Article 226 of the Constitution. Now the question is whether environmental law is public law or whether it is private law. So a quick spoiler: environmental law is both public law and private law. We'll see why. So environmental law as public law. So the subject environmental law has no territorial limits. There is no territorial limits or boundaries like the Indian Contract Act 1872, Indian Evidence Act. So there is no territorial limits, the very first point. Whereas personal laws like Hindu Marriage Act 1955 and the succession apply to Hindus only. Similar is in the case of Muslim and Christian laws. So there are territorial limits to the other acts. Environmental law is a public law because it has no territorial limits. According to N.D. Tiwari Committee Report 1980, there are about 200 central and state statutes. Not really important. No need to go through this particular part. But the principle of environmental statute, this is good. Principle of environmental statutes are 12. So there are 12 principles of environmental statutes. There are 12 principles of environmental statutes, and it includes things like Environment Protection Act, Water Prevention and Control of Pollution Act 1981, National Environment Tribunal Act. Okay, so we have Environment Protection Act, Water Act, National Environment Tribunal Act, etc. There's other things also like Wildlife Protection Act. There is I guess Indian Forest Act. So there are many other things. The main objects of all the environmental legislation is to regulate human behavior so as to control the environmental pollution. So the main object of the environmental legislation is to regulate the human behavior so as to control environmental pollution. The concept of environment is a global phenomenon, since no state, nation or country has the environment of its own. Environment belongs to everyone. So the concept of environment is a global phenomenon. In other words, environment is one and the same in the entire universe as in the case of sun and earth, since that is also something which everyone possesses it. It's everyone's. So environment is also everyone's. However, it may vary from state to state. Environmental law. However, environmental law may vary from state to state or country to country. Acquisition and laws of territories take place on the earth, resulting in environmental complexities. So the acquisition and loss of territories take place on the earth, resulting in environmental complexities. Thus, every nation must feel environmental problem as the national problem and should take necessary steps to protect and improve the environment. So everyone, collective responsibility. In the above discussions, environmental law may be regarded as branch of public law. Right. When we talk about environmental law as a private law, environmental pollution causes damage not only to the public as a whole, but also to the individuals or group of individuals in particular. So it not only causes damage to public, but also to individual or certain groups of individuals in particular. So when an individual is affected, he alone can move the court under the principle of locus standi. When public as a whole is affected, any public spirited citizen can move the court by filing public interest litigation. Okay? Thus, environmental law may be regarded as a branch of private law. So, even a person who has caused the grievance, who is being affected, can also have the locus standi to approach the court directly. So, therefore, it is a private law also. It is both public and private law. In view of the above discussion, we cannot rightly say that environmental law is neither purely a branch of public law nor purely a branch of private law. Much can be said on both sides. Therefore, it is a branch of public law from the broader point of view and also a branch of private law from the narrower point of view. So there is two aspects. A broader point of view, you would say it is public law, and from a narrower point of view, you would say it is private law. Right, next slide. Sustainable development. Next topic, more like. Okay. The concept of sustainable development. The concept of sustainable development was first brought in the use in the year 1970 by Cocoyoc Declaration. So Cocoyoc Declaration was the first one where we brought the term sustainable development onto the table. Therefore, thereafter the concept was well developed at international level. The concept of sustainable development means that at the time of developing ourselves economically, industrially, technologically, we shall be very careful and shall provide the environment protection. So while we develop ourselves economically, industrially and technologically, while we develop ourselves economically, industrially and technologically, we shall be very careful and shall provide the environment with its protection. Economically, industrially and technologically, we shall be very careful and shall provide the environment with its protection during the time of our development in these aspects. This is an important concept. So this is the concept of sustainable development. While we develop ourselves economically, technologically and industrially, we shall give protection, we shall be very careful and we shall give the environment with its protection, right? So the expression sustainable development means development that meets the needs of the present without compromising the ability of the future generations to meet their own needs. So the expression sustainable development means development that meets the needs of the present. Development that meets the needs of the present without compromising the needs of the without compromising the ability of the future generation to meet its needs. Without compromising the ability of the future generation to meet their own needs. Okay. Sustainable means development that meets the need of the present without compromising the ability of the future generation to meet their own needs. Okay. Next, meaning of sustainable development. So the meaning of sustainable. We did the meaning. This is also meaning of sustainable development. And oh my god, terrible. I've always said things, but I always say it. Writing with mouse can be a pain. Okay, moving on. Meaning of sustainable development. SR Oil Limited versus Halar Utkasha Samiti. So meaning of sustainable development was read into was read in this landmark judgment, SR Oil Limited versus Halar Utkasha Samiti. This is the very first case that we are referring to. In fact, in the channel also, this is the very first case. The SR Oil Limited versus Halar Utkasha Samiti. The Supreme Court in this case retreated that sustainable development aims at balancing economic and social needs on the one hand with environmental considerations on the other. Sustainable development aims at balancing economic and social needs on one hand and environmental consideration on the other. Economic and social needs on one hand and environmental consideration on the other hand. Balance them. Balancing the economical and social needs on one hand with the environmental consideration on the other. Development should not become a environmental threat because clean environment is necessary for the very existence of human beings and other organisms. So development should not become a environmental threat because clean environment is necessary for the very existence of human beings and other organisms, and we need development also. Okay. The environmental legislation should aim at creating sustainable development aims at balancing economic and social needs on one hand and the environmental consideration on the other. Now, the environmental legislation should aim at creating harmony between development and environment. Should aim at creating harmony between development and environment, since neither one can be sacrificed at the altar of the other. Okay, neither one can be sacrificed at the altar of the other. There should be a harmony between development and environment in order to sustainably develop. Harmony between development and environment so that neither one can be sacrificed at the altar of the other. Okay. Now, sustainable development itself means this very thing: balancing economic and social needs on the one hand with environmental consideration on the other. The environmental legislation should aim at creating harmony between development and environment considerations. Okay, so that was given in SR Oil Limited versus Halar Utkasha Samiti. Okay, SR Oil Limited versus Halar Utkasha Samiti. The next one is ND Dayal versus Union of India. How many cases are there? Okay, that's it. Fine. ND Dayal versus Union of India. So in this case, the Supreme Court held that sustainable development which relates to environmental protection is inherent in a right to life under Article 21 of the Constitution, and therefore it should be given due importance as a fundamental right in the process of economic and industrial development. So sustainable development which relates to environmental protection is inherent in right to life under Article 21 of the Constitution. So sustainable development which relates to environmental protection is inherent in right to life under Article 21, and therefore it should be given due importance as a fundamental right. Therefore, sustainable development which relates to the environmental protection is a fundamental right because it is inherent in the right to life under Article 21 in the process of economic and industrial development. Fundamental right in the process of economic and industrial development. Sustainable development which relates to environmental protection. Sustainable development which relates to environmental protection is inherent in right to life under Article 21. Therefore, it should be given the same importance as that of a fundamental right in the process of economic and industrial development. So that was given in this case, ND Dayal versus Union of India. ND Dayal versus Union of India is where this was said. Sustainable development which relates to environmental protection is an inherent right to life, and therefore it has the same weight as that of a fundamental right in the process of economic and industrial development. Okay. Today, environmental degradation is a serious threat to global substance. But just before that, there are two cases we referred to. One is SR Oil Limited versus Halar Utkasha Samiti. The other one is ND Dayal versus Union of India. In this, we discussed about the meaning of sustainable development. We said that sustainable development, not the meaning, the aim of sustainable development is to create a balance between the economic and social needs on one hand and the environmental consideration on the other hand, and that there should be a harmony between development and environment, and neither one can be sacrificed at the altar of the other. And the other one, ND Dayal versus Union of India, we said that sustainable development which relates to environment protection is a fundamental right, is inherent in the right to life, and therefore it has the same importance as that of fundamental right in the process of economic and industrial development. Okay, so today environmental degradation is a serious threat to global substance. The efforts made by the states at national and international level are at full swing to combat the increasing environmental pollution. Therefore, the modern law relating environmental pollution has the main objective of achieving sustainable development for safety and protection of environment. The sustainable development is one of the underlying principles of environmental law. So sustainable development is one of the underlying principles of environmental law. Anyway, the main principle of sustainable development is that for economic and industrial development, we cannot compromise with environment. For economic and industrial development, main principle of sustainable development is that for economic and industrial development, we cannot compromise with the environment. And this economic and industrial development thing, it was here. Environment protection. For economic and industrial development, we cannot compromise with the environment. Therefore, our economic and industrial growth should not be adverse to the environment, but at the same time, we must have friendly schemes and plans for the environment also. Therefore, our economic and industrial growth should not be adverse to the environment, but at the same time, we must have friendly schemes and plans for the environment also. Objectives of sustainable development: to maintain a balance between ecology. Okay, so these are the objectives. What are the objectives of sustainable development? Maintain a balance between ecology and development. Balance between ecology and development, number one. Number two, maintain production of goods and services for development and efficiency. So maintain the production of goods and services for development and efficiency. It's not okay, it's conservation. Conservation and management of natural resources, including preservation of biodiversity and maintenance of biological integrity. So conservation and management of natural resources. Okay, conservation and management of natural resources, including the preservation of biodiversity and maintenance of biological integrity. Including preservation of biodiversity and maintenance of biological integrity. Maintenance and enhancement of the quality of life. Conservation. Okay, so conservation is another aspect. Management of natural resources. Okay, conservation and management of natural resources. Fourth, maintenance and enhancement of the quality of life. Quality of life, adopting principles of equitable distribution of wealth, and material resources. So maintenance and enhancement of the quality of life. Maintenance and enhancement of the quality of life. And also to adopt principles of equitable distribution of wealth and material resources. Equitable distribution of wealth and material resources, and maintenance and enhancement of the quality of life. So these are the objectives of sustainable development. 1. Maintain balance between ecology and development. Second is to maintain production of goods and services maintain the production of goods and services for development and efficiency. Third is conservation and management of natural resources, including the preservation of biodiversity and maintenance of biological integrity. Biological diversity and maintenance of biological integrity. Okay. And fourth is maintenance and enhancement of the quality of life, and also to adopt equitable distribution, maintenance and enhancement of quality of life, and equitable distribution of wealth and material resources. So these are the objectives of sustainable development. We move on. Next is salient features or characteristics of sustainable development. Salient features of sustainable development. 1, 2, 3, 4. No. This is 4. Poverty eradication. This is 5. Obligation to assist and cooperate. 6. Principle of public trust. 7. Intergenerational equity. 8. Director's responsibility. And then we have conclusion. So there are 8 points when we talk about the salient features or characteristics of sustainable development. So the very first aspect is the environment protection. So environment protection is of vital importance. The sustainable development provides that our economical or industrial progress must not affect the human environment. Industrial and economical development must not compromise the human environment. It does not mean that we shall restrict the economic and industrial progress, but it simply suggests that at the time of progressing ourselves, we shall be very careful of the thing that we learned in the previous slide. Anyway, so environment protection is one thing. One important salient feature of sustainable development, environment protection. Second, okay, now there is a case here: Citizen Consumer Forum and Civic Action Group versus Union of India. Citizen Consumer Forum and Civic Action Group versus Union of India. In this case, court held that while courts have social accountability in the matter of protection of environment, there should be proper balance between the same and development activities which are essential for progress. There can be no dispute society has to proper, but it shall not be at the expense of environment. I don't know, don't go through it. Something's wrong here and didn't really seem to be that important. Anyway, the environment shall have to be protected, but not at the cost of development of society. So basically the same thing which we learned, that's what this case here has to say. Citizen Consumer Forum and Civic Action Group versus Union of India. The environment shall have to be protected, but not at the cost of the development of society. Environment shall have to be protected, but not at the cost of the development of society. Both development and environment shall coexist and go hand in hand. Both the development and the environment Both development and environment shall coexist, and it will go hand in hand. Citizen Consumer Forum and Civic Action Group versus Union of India. Anyway, so that's about environment protection. Second is precautionary principle. The sustainable development binds us to take all necessary precautions for preventing pollution of human environment, and so as to provide wholesomeness of human environment. So sustainable development binds us to take all necessary precautions for preventing pollution. We need to take precautions for preventing pollution of the human environment, and so as to provide wholesomeness to human environment. While carrying out industrial and technological development, we shall take due care and precautions for preserving the natural environment. It was during 1970s that the term Versorgungsprinzip was used in Germany's industrial sector. So I definitely pronounced it wrong. This is pronounced some other way. It's German. Versorgungsprinzip. I don't know. How does German go? I don't know. Versorgungsprinzip, which meant foresight principle. Okay? Foresight principle, requiring precautionary steps to prevent likely disaster. Okay, requiring precautionary steps to prevent likely disaster. It's called the foresight principle. German industrial sector was where it came out from. Versorgungsprinzip, foresight principle. Okay, the principle carries the ideas that much of the environmental degradation can be prevented if timely precautionary measures are taken at the time of installation of the industry or hazardous undertaking. So when industries are established, at that time itself, if precautionary principles can be taken, then much of the environmental degradation can be prevented. So that is precautionary principle. So the very first one that we did was environment protection. We dealt with this case, Citizen Consumer Forum and Civic Action Group versus Union of India, and then we talked about precautionary principles. Okay, and then we come to the third part, that is polluter pays principle. So this is another characteristics of sustainable development. This principle mainly suggests two things. Firstly, it provides that as human beings are entitled for having natural environment, any damage caused due to environment pollution shall be compensated. So human beings are entitled for having the natural environment, and therefore any damage caused to the environment shall have to be compensated. And secondly, it provides that the responsible person shall pay the compensation needed for restoring the environment. So the person who was responsible for the activity shall pay the compensation needed for restoring that environment. Okay, so there are two principles in the polluter pay principles. Firstly, human beings are entitled for having natural environment, and therefore any damage caused has to be compensated. And secondly, it provides that responsible person who did the act shall pay the compensation needed for restoring the environment. Okay, so that is about the polluter pays principle. So first thing that we did was environment protection. Second, we did precautionary principle. In this case, Citizen Consumer Forum and Civic Action Group versus Union of India. And then we did polluter pays principle after precautionary principle. Right. And there is a case in polluter pays principle, that is Sterlite Industries India Limited versus Union of India 2013. So in Sterlite Industries India Limited versus Union of India 2013, the Supreme Court in this case applied the polluter pays principle, and considering the magnitude, capacity and prosperity of the appellant company, directed it to pay compensation of rupees 100 crores for failing to maintain emission and effluent standards and operating the plant without renewal permission, and thereby causing air and water pollution which could have been averted. So that's where the polluter pays principle. So a company was made to give a large sum of money because it could not keep up with it failed to maintain the emission and effluent standards, and it did not take any renewal permissions, and therefore it caused violation of air and water pollution provisions and caused a lot of air and water pollution. So, and that could have been averted. So the company was made to give a large sum of money, and polluter pays principle was put into use. So that is the case of Sterlite Industries India Limited versus Union of India 2013. Sterlite Industries India Limited versus Union of India. Okay, next case, MC Mehta versus Kamal Nath. In this, Supreme Court observed that polluter pays principle has been recognized as fundamental objective of government's environmental policy to prevent and control pollution. So, polluter pays principle is the fundamental objective of government environmental policy. Polluter pays principle is the fundamental objective of government's environmental policy to prevent and control pollution. The court in this case observed that the calculation of environmental damages should not be on the basis of the claim put forward by party, but it should be on the basis of examination. It should be on the basis of examination of the situation by the court. The calculation of environmental damages should not be on the basis of the claim put forward by the party. Calculation of environmental damage should not be on the basis of claim, but it should be on the basis of examination of the situation by the court, keeping in view the factors such as deterrent nature of the award. The court further held a person who is guilty of causing pollution has to pay damages for restoration of the environment and ecology. So the person who is guilty of causing pollution has to pay damages for the restoration of environment and ecology. So that was given in MC Mehta versus Kamal Nath. So there are two cases we did: Sterlite Industries India Limited versus Union of India, and we did MC Mehta versus Kamal Nath. Fourth point, poverty eradication. One of the causes of environmental pollution or degradation is poverty, which should be eradicated at global level. Most of the developing countries are facing the problem of poverty, which is adversely affecting the environmental quality. Earth Summit 1992 also projected that elimination of poverty was utmost necessary for achieving the goal of sustainable development, particularly in the developing countries. So poverty eradication is another reason why there is environmental pollution, and therefore those countries which are developing and are faced with the problem of poverty adversely are adversely affected are adversely affecting the environment quality. I don't know how exactly it is, but for the sake of the exam, yes. Okay. Earth Summit 19 also projected that elimination of poverty was utmost necessary for the achievement for achieving the goal of sustainable development. These are the salient features of sustainable development. Okay. So we have environment protection, we have precautionary principle, we have polluter pays principle, and now we are saying poverty eradication. Yeah, sustainable development aims at reducing poverty also. Okay, sustainable development aims at eradication of poverty, and that can help in reducing environmental pollution somehow. Okay, so in the Treaty of Rome on environmental cooperation as amended in 1992, the Treaty of Rome on environmental cooperation as amended in 1992, the developed countries are urged to help and assist the developing and underdeveloped countries by providing them technological assistance at a reduced rate and financial support for sustainable development. So it's for the developed countries are urged to help and assist the developing and underdeveloped countries by providing them with technological assistance and at a reduced rate and financial support for sustainable development. So what are the things that they're supposed to provide a developing country with, or an underdeveloped country with? A developed country must provide technological assistance. And it should be at a reduced rate. Technological assistance should be given, and that assistance should be given at a reduced rate, and financial support should also be given. Okay, that was told in the Treaty of Rome on environment. Okay, moving on. Fifth, so this was poverty eradication, Treaty of Rome. Okay, fifth, obligation to assist and cooperate. Having regard to principles of Stockholm Declaration, obligation to assist and cooperate. Having regard to principles of Stockholm Declaration, every state is bound to cooperate and assist other states in matters of protecting environment and stepping towards protection of environment. Having regard to principles of Stockholm Declaration, every state, this is the thing. Having regard to Stockholm Declaration, every state is bound to cooperate and assist other states in matters of protecting environment and stepping towards protection of environment. So here the urge, here the request, not request. Here the duty was of the developed countries to help the underdeveloped and developing countries by providing them technological assistance and financial support. Here, no matter if you are developed or underdeveloped or developing, there is a duty on every state to cooperate and assist each other in the matters of protecting environment and stepping towards protection of environment. So that is the obligation to assist and cooperate. Moving on, sixth principle of public trust. Principle of public trust. So the sustainable development obliges us to preserve and conserve the natural resources for making them available that's the best I can do. Okay. The sustainable development obliges us to preserve and conserve the natural resources for making them available for future generations. It is to be noted that every generation have right to exploit the natural resources, but it should be in the optimum form. So this is an ode to us. Not this is a duty on us. Okay, the sustainable development obliges us to preserve and conserve the natural resources for making them available for future generations. Principle of public trust. It is to be noted that every generation have right to exploit the natural resources, but it should be in the optimum form. National resources like air, water, sea, rivers, etc. are gifts of nature. Okay, national resources like air, water, sea, river, etc. are gifts of nature. The principle of public trust envisages that the government must take all necessary steps for the protection and conservation of these natural resources. So the duty is also on the government to take necessary steps for the protection and conservation of these natural resources. So that's the principle of public trust. Okay, conservation of these natural resources and should be vested in government. Okay, so this duty is not only on us but also on the government, and it should vest in the government. Okay, it should vest in the government. It should not be transferred to private hands. So sustainable development obliges us to preserve and conserve the natural resources for making them available for future generation. Preserve and conserve the natural resources. Every generation has right. Natural resources like air, water, sea and river are natural gifts, and therefore the principle of public trust envisages that government must take all necessary steps for protection and conservation of these natural resources, and therefore it should be vested in the government and it should not be transferred to private hands. Every person who exercises right to use natural resources like air, water, land has a duty to make sustainable use of them so as to make sure that others are not deprived of their similar right of use, and it does not adversely affect the environment and the ecosystem. So every person who exercises the right to use natural resources like air, water, land has a duty. So we also have the duty, and the government also has the duty to take care of these things. So those are the principle of public trust. Moving on, seventh point, intergenerational equity. Seventh point is intergenerational equity. It means maintaining equality among different generations. Maintaining equality among different generations. However, intergenerational equity is necessary for the development of present generation as well as for the future generations development. So it's for the development of both the present generation as well as for the development of future generations. It is to be noted that unless we care for the rights and benefits of future generations, sustainable development cannot be as sustainable. So unless we care for the rights and benefits of future generations, sustainable development cannot be as sustainable. We have to care for the future generation also. Okay, so that is about intergenerational equity. Now we move towards director's responsibility. Eighth point. This principle says that directors should be held liable for violation of environmental norms. Directors should be held liable for the violation of environmental norms in order to create deterrent effect on the polluting industries. In order to create deterrent effects. The term deterrent means to scare someone or something like that. I don't exactly remember, so we'll check. Deterrent, a thing that discourages or is intended to discourage someone from doing something. Yeah, scare kind of thing. Yeah. So directors should be held liable for violation of environmental norms in order to create a scare or in order to create a deterrent effect on the polluting industry. Okay, so in MC Mehta versus Union of India, the courts have emphasized that the directors should give undertaking that if any accident occurs due to the hazardous acts of the industrial corporation, the directors should be personally liable. So directors should give an undertaking that if any accident occurs due to the hazardous act of the industrial corporation, the director will be personally liable. So that was given in MC Mehta versus Union of India. MC Mehta versus Union of India. This is quite an important thing here. Okay, so deterrent effect and MC Mehta versus Union of India is a very, very important thing here. Okay. Right. In another pronouncement, Uttar Pradesh Pollution Control Board, UP Pollution Control Board versus Mohan Meekings Limited. Courts have imposed statutory liability on the directors under the provisions of anti-pollution laws. Is that it? Okay, no need. We don't go into this thing. We just talk about MC Mehta versus Union of India. Problem solved. Okay. So directors will be personally liable if any accident occurs and they are supposed to give an undertaking for the same. Okay. So directors' responsibility over. We are done with all the 8 points. The first one we did was environment protection. Second, precautionary principle. Third, polluter pays principle. Fourth, poverty eradication, right? And fifth, obligation to assist and cooperate. Sixth, principle of public trust. Wait 1 second. Then fifth is obligation to assist. Principle of public trust. Sixth, and then seventh, intergenerational equity, and eighth we have director's responsibility. Problem solved. Next is about conclusion. The natural resources have got to be trapped for the purposes of social development, but at the same time we have to be cautious that ecology and environment may not be affected in any serious way. There should be long-term planning to keep up national wealth. Preservation of environment and keeping the ecological balance unaffected is a task which the government as well as the citizen has to undertake. Done. Now what do we do? Should I limit the video here? 1 hour done. I think I'll stop here and I'll do this thing in a different video. We've got a long way to go, however. 74, we are almost there to 100, but we're not. Okay, we stop here. I'll take a 5-minute break and I'll continue.